Hi, Joanna.
Hello, Valeria.
We have been receiving a lot of demands from our clients regarding the virtual asset service providers. So I was hoping you could clarify some common doubts about this topic. So, first and foremost, what is the legal status of crypto assets in Portugal?
Okay, first I need to clarify that crypto assets might be qualified as virtual assets, securities, or electronic money. If qualified as securities, the Portuguese Securities Market Code and the respective regulation applies. If the crypto assets are considered as electronic money, it is applicable the Decree Law 91 2018 that regulates the payment, service provision, and the electronic money services. Nonetheless, most of the crypto assets are qualified as virtual assets, and that is the main reason why in the public sphere we heard so many times or hear so many times that it's not yet regulated. And that at the moment is in part true. Crypto assets have no specific legal status as per the exception of the anti-money laundering and finance terrorist regulation. Bank of Portugal and the Portuguese Market Commission at a national level, as well as the European institutions, have been unanimous in not considering cryptocurrencies as legal tender and have not yet issued any specific regulations. The exception is, of course, the prevention of money laundering and terrorist financing, the AML-CFT. Notwithstanding, we have strong motives to believe that by the end of the year, the European regulation, the MiCA, which is the Regulation on Markets in Crypto Assets, will be published and come to force. Very recently, on May 2nd, a regulation on a pilot regime for market infrastructure based on a distributed ledger technology was published and will come to force in June 22nd, which obviously will apply to all European countries directly. On a tax level, much has been said in the public forum, namely in the past weeks. The Minister of Finance announced that Portugal will soon adopt legislation regarding the taxation on cryptocurrencies to avoid legal loopholes. However, for now, cryptocurrencies are not on an individual level being regulated. So, you, as a natural person that invests on a personal level, are not taxed with 28% of the obtained gains.
Thank you. Now, the second most common doubt we have been receiving is what is necessary nowadays to obtain the license for virtual asset service providers. Can you clarify that, please?
Yes. So let's start by calling these companies the VASPs. It's easier. So the virtual asset service providers. First, you must either incorporate a traditional limited liability commercial company or adapt and transform an already existing one. Therefore, you need to obtain an admissibility certificate, in Portuguese shortly referred to as CAF, and the company's registration, indicating the headquarters, the shareholders, and so on. The difference is related to the corporate purpose, which must be adapted to the definition of the virtual asset activity or activities that the shareholders propose to carry out through the VASP. Second, it is necessary to draft a business and activity plans that detail, among other things, the internal organization and corporate structure, including, for instance, the responsibility for the performance of compliance for AML and CFT purposes, and the demonstration of the economic viability of the VASP to be registered. Third, all VASPs shall adopt policies and procedures that are sufficiently effective to ensure compliance with the regulation currently in force, considering its nature, size, and the complexity of the activity to be pursued, namely regarding the client's onboarding, the anti-money laundering, security, risk, subcontracting, archive, and data protection. So there are naturally some detailed specifications that must be considered with the clients, despite the inexistence of the specific legislation. For instance, the subscription of an insurance. Finally, the submission implies the filling of a form provided by the Bank of Portugal that must always be filled out in the Portuguese language.
Okay, so thank you. You mentioned the VASP. Another doubt we have been receiving is what is the process of the VASP's incorporations? Can you clarify that, please?
Sure. So the company incorporation should take no more than 1 week. Then the lawyers must, together with the client, start drafting all of the governance arrangements, some of which I already mentioned, so the client's onboarding, the MLCFT and policy and procedures, etc. That should take more or less 1 month. And after that, you submit the registration application. The Bank of Portugal has between 3 and 6 months to authorize the registration of the VASP, counted from the date of the receipt of all the instructive elements. It should be noted that Bank of Portugal may request the applicants for additional information, so between this period, as well as carry out the verifications or the investigation that it deems necessary. After 6 months, if the Bank of Portugal does not notify the VASP, there is a tacit approval of the request for the authorization.
Thank you very much for your clarification.
Thank you.